Okay, so good afternoon. First, I want to welcome you to today's event. It's good to see so many people here, and hello, people in the overflow room. There are, as promised, there is going to be lunch. Lunch will be available as you exit at the end of the program. I am joined today. Well, I'm Jason Mazzoni, by the way, and I'm joined today by my friend and dean, Vic Amar, and also we're very delighted to have Alicia Urube Maguire here joining us from the Political Science Department. So welcome to you, and a special welcome to some of her students who are in the audience today. We can direct you to the law school admissions office right after if you want. I just want to say a few things by way of introducing the event. Our topic is the 2020 presidential election and the U.S. Supreme Court. But first, I thought I'd say a little bit about why we are here. Today is Constitution Day, September 17th. It's actually officially Constitution Day and Citizenship Day. So that's what a federal statute. It's 36 U.S.C. Section 106 says, and the same statute requires every educational institution that receives federal funding to hold an educational program on the Constitution. The funding piece is important because Congress couldn't otherwise just order us to hold this kind of event. One thing you learn in constitutional law is that the states, and we are the state, we're not puppets of the federal government, but Congress can offer the money and say, if you want to take the money for running your university, please do this. And we thought about it and we said, sure. And so that's why we're here. I'll get to the significance of the date, September 17, in just a moment. But I said it's Constitution Day and Citizenship Day. And the statute says that we are commemorating not just the Constitution, but also, quote, recognizing all who by coming of age or by naturalization have become citizens. Well, that's a little odd. The statute suggests that even if you are born in the United States, you only become a citizen when you reach adulthood. But that's not right. The 14th Amendment of the Constitution makes, with very limited exceptions, everyone who's born in the United States a citizen at birth. There are a few places in the Constitution where adulthood as a textual matter does matter. So in Article 1, representatives have to be at least 25, senators at least 30. Article 2, the president has to be at least 35. No minimum age, by the way, for the judges or justices of the Supreme Court. No maximum either. We might get into that in a moment. And judges, by the way, don't even have to be citizens to serve. And then elsewhere in the Constitution, the 14th Amendment provided that if states after the Civil War and with Reconstruction denied voting to male citizens who were 21 or older, they would lose representation in the House. So this was a sort of incentive mechanism to get them to extend voting rights to black citizens after the Civil War. And then the 26th Amendment is the other place where adulthood does matter in the Constitution. The 26th Amendment is a provision that prohibits denying the right to vote to individuals who have reached the age of 18, ratified in the context of the Vietnam War. But this general idea that's reflected in our Constitution Day statute that you somehow attain citizenship at adulthood is not a part of the Constitution itself. That said, there is maybe some traction to the idea that there is something special about being an adult citizen within our system of government. We don't let 5-year-olds vote or serve on juries. We haven't so far sent child soldiers into battle. We don't execute children, even if they commit horrible crimes. There are lots of ways in which ordinary law, even if not constitutional law, does treat children differently from adults. So in the sense that you obtain perhaps fuller citizenship with some more rights and obligations upon adulthood, has at least some cultural traction, even if it doesn't match up to the text of the Constitution itself. And one thing that happens when people start talking about the Constitution, for example, during the course of a presidential election, what they say doesn't always match up with what the Constitution says either, even though there might be social or cultural resonance to the message that they are giving you. The other thing that I wanted to flag about the statute is that this fusion of the two things, the Constitution and citizenship, might be a bit misleading, because it might suggest that the Constitution only applies to citizens. That's not the case. The structures of government that the Constitution creates reach non-citizens when Congress enacts statutes pursuant to its enumerated powers under the Constitution. Those statutes can, I think without question, reach non-citizens. And then on the other side of the equation, nobody thinks that only citizens of the United States enjoy any of the individual rights provisions of the Constitution. All of the criminal procedural protections, for example, those apply to citizens or non-citizens put on trial in our system. Okay, so why September 17th? Why did Congress pick that date? Well, that's a date in 1787 when a majority of the delegates to the Philadelphia Convention, 39 out of 55, signed the document that they'd written. So this is the end of the hot summer. They've been laboring over the document. It's gone through multiple drafts, and it's been debated and modified, been written up, and now we sign our names. It tells us something about how we think about the Constitution, that September 17 is the date selected for Constitution Day. Right? This date places a great deal of significance on the drafting of the Constitution in Philadelphia. But if you think about it, there might be better choices, and we would be expressing a different sense of history, of the document, a different sense of our political understanding of it if we were to pick a different date. So let me give you a few alternatives to think about. September 20, 1787, the document, the draft Constitution, reaches Congress. What does Congress do? It says, we're not happy with the fact that there's this new Constitution. Those delegates, their job and their authority was limited to revising, amending the Articles of Confederation. Instead, they've written up this whole new thing, and we might be inclined to censor them. And there's debate over that for a few days. So September 20 is significant in that sense. The document reaches Congress under this cloud of illegitimacy. Congress thinks about it for a little more than a week. September 28th, Congress says, oh, never mind, we're going to send it on to the states. And that's a really important date because that's the thing that gets the ball rolling. Once again, it could have died in Congress at that point. So September 28th, might be a date on which we celebrate Constitution Day instead. But maybe that's not the right date either, because at this point, it's still just a proposal. It's easy to propose something, much harder to get something adopted, and so more worthy of celebration when you manage to do that. The Constitution said that it would take effect when 9 states had ratified, so take effect among those 9 states. That takes a little while. Ratification is not at all a sure thing, but you get Delaware. First state ratifies on December 7th, 1787. Right, first state ratifying it. So perhaps that's the date that we should recognize. We could call it Delaware Day and be celebrating that. And yet, it's still just a draft because nobody is bound by it, not even the people of Delaware who have said yes. So maybe you wait until you get the 8 more states on board. That happens when New Hampshire ratifies June 21, the following year, right, 1788. So that's when the Constitution takes effect among those 9 states. So maybe you pick that date, New Hampshire Day, right, rather than Delaware Day. It's not so crazy because when we start to talk about presidential elections, New Hampshire, right, small state, plays an outsized role in presidential elections, so perhaps some connection there. Or maybe you say, well, let's wait till all of the states are in. That's May 29, 1790, when Rhode Island, the holdout, narrowly votes to approve the Constitution. And so May 29th is an alternative. We keep going down this path. You might think the Constitution isn't really a Constitution without the Bill of Rights, right? That's something that I think is really important to the Constitution, and so that's the thing that we should be celebrating, the addition of the first 8 or 10, depending on how you count amendments to the Constitution. Those are approved by Congress on September 25th in 1789, then sent to the states. The ratified take effect at the end of the year, December 15th, 1791. And so perhaps that's a better choice for thinking about the Constitution as also incorporating those important provisions. But then all of this focuses on the founding era. Our Constitution, though, is not the Constitution of James Madison or Thomas Jefferson. It's the Constitution of Abraham Lincoln, right? That's why you came here to study law and you didn't go to Charlottesville. Because there's a civil war that results in an overhaul of what existed before a Second Republic, a new document in many ways. In this sense, there's no better place to be commemorating Constitution Day than right here, right in this classroom in Illinois. We are the epicenter of constitutional history in the modern sense. And so lots of other possible dates once you go down that path. December 6th, 1865, the 13th Amendment is ratified, abolishes slavery, altering some key provisions of the Constitution, recalibrating the federalism balance that exists at the outset. July 9th, 1868, 14th Amendment is ratified, giving you birthright citizenship, right? Remember our statute, plus lots of restrictions on the states, right, including provisions that will result in the Bill of Rights being applied against them. The sort of modern understanding, right, of constitutional rights comes out of the addition of the 14th Amendment. And we can kind of keep on playing this game. Maybe the 15th Amendment, right, which prohibits denying the right to vote on the basis of race, right, might be the point that you think about the beginning of our modern Constitution. That's February 3rd, 1870. Or the 19th Amendment, which will turn 100 years next August, so August 18th. Prohibiting denying the right to vote on the basis of gender. And then maybe we don't limit ourselves to specific articles or amendments in the Constitution itself, because there are some statutes out there that are such an important part of our constitutional system that perhaps those are the things that you would want to focus on, things like the Voting Rights Act of 1965, August 6th of that date, signed into law by President Johnson. So all this is just to suggest that when you start thinking about the day on which you want to commemorate the Constitution as you understand it, there are a variety of choices with, I think, some different implications for how we understand the document itself and the full trajectory of constitutional history. Okay, so we turn then to the Supreme Court, and I wanted to start with that. I wanted to touch on that second, because the court is not equal to the Constitution, and this is not Supreme Court Day, but we are going to talk about the Supreme Court. The Supreme Court obviously matters. It's always talked about in presidential elections, the things that we're going to focus on for the remainder of the hour. So remember last time, the Republican nominee gave us a list, two lists, from which he said, these are the people. If I have a chance to put somebody on the Supreme Court, I'm going to pick from the names on these lists. And he did that, and they are on the court. Right? 2 Trump appointments, maybe more to come. We'll see how things play out. You say what you will about the chaos of the Trump administration. When it comes to judges, this is a well-oiled machine. It has been extraordinarily successful in judicial appointments. And the presidential challengers this season on the Democratic side have also had some things to say about the court, the Supreme Court, and the lower federal courts as well. And not just who is appointed, the kinds of justices that they would name, the kinds of justices that they think should serve, but also there's talk about altering the form and function of the Supreme Court. And so I want to close with 2 things in this regard, both recently in the news. First, several of the Democratic candidates over the weekend you may have seen calling for the impeachment of Justice Kavanaugh. If you're keeping score, Warren says yes, Biden says no. And then a case that I want to mention because it, I think, indicates in some ways the sort of climate that we are in and that we're going to be heading increasingly in the coming months. I direct our program here in constitutional law, and we put on a lot of events. You should come to all of them. They're always great. And each year in the spring, we have an event highlighting cases on the Supreme Court's current docket. And back in the spring, back in March when we did this earlier this year, one of the cases that I talked about was a case called New York State Rifle and Pistol Association versus New York. That's a case that challenges a New York City regulation that said that you couldn't transport a lawfully owned firearm outside of your New York City residence, except if you're going to one of 6 or 7 designated firing ranges for target practice within the city of New York, and then returning, directly home. And so you couldn't, for example, take your firearm to your second home, which many New Yorkers have, in Connecticut. This regulation then is challenged as in violation of the Second Amendment. There's some additional challenges as well, and the Supreme Court granted review in the case. After the court granted review, New York City amended the regulation because I think they understood that the Supreme Court was going to invalidate the restriction, but more importantly, because if it did that, which I think was likely, along the way it might say something really expansive about Second Amendment rights. It might have lots of implications for other sorts of laws around the country. Who knows, but that was probably the sense in New York City. And then New York State, to sort of belt and suspenders approach, also enacted a statute prohibiting cities in New York from reenacting any similar ordinance. The city then asked the Supreme Court just to dismiss this case as moot. Right? You probably already heard about mootness, even in your first couple of weeks of law school. But the challengers, represented by your friend Paul Clement, said, "Oh, no, not so fast. It's not moot." And it had a couple of reasons. One of which is probably the strongest, that in amending the regulation, New York City said, you can transport your firearm around the city, say to your second home, but you cannot stop, for example, for gas anywhere along the way. And so the court should continue to keep the case on the docket. 5 Democratic senators, including then presidential candidate, no longer in that category, Kirsten Gillibrand from New York, and our own Dick Durbin, wrote an amicus brief supporting dismissal of the case, urging the Supreme Court to dismiss the case. The brief, it's quite a read, says nothing about mootness doctrine, but instead tells the court it should butt out of issues best left to legislatures, that the court has become overly politicized and Americans don't trust it, that the case at issue is the handiwork of the Federalist Society and the NRA, that Republican appointees on the court right now have been pursuing a political agenda, including by manipulating rules of standing. And then they end with this paragraph: the Supreme Court is not well, and the people know it. Perhaps the court can heal itself before the public demands that it be restructured in order to reduce the influence of politics, particularly on the urgent issue of gun control. A nation desperately needs it to heal. Now, when I read the brief, I was reminded of what President George W. Bush reportedly said after hearing Trump's inauguration speech, quote, "That was some weird shit." That brief quickly generated a letter, not a brief, to the court, signed by every Republican in the Senate saying, "We take no position on the case before you, but, quote, judicial independence is under assault. Democrats in Congress and on the presidential campaign trail have peddled plans to pack this court with more justices in order to further their radical legislative agenda. They are a direct, immediate threat to the independence of the judiciary and the rights of all Americans." They end by saying, "We share Justice Ginsburg's view," probably only time, but we share Justice Ginsburg's view, she said this recently, that 9 seems to be a good number, and it isn't going to change so long as we, Senate Republicans, are here to protect you. On Friday, the Supreme Court set the case for argument on December 2nd. So with that by way of introduction, Alicia, we will hear from you.
All right. There we go. So I'm going to start a little bit by talking about the role that the Supreme Court played in the 2016 election. So Jason mentioned that, in a lot of elections we hear the Supreme Court mentioned, but I don't think quite to the extent that we did in the 2016 election. Many Republicans listed the Supreme Court as one of their number 1 reasons for voting for Trump. And actually, I have a research project where I'm looking that this is particularly important among evangelical Christians in the 2016 election, which potentially brought in a group of people that might have been less favorable towards Trump otherwise. So he said, "I've got this list of individuals that I'm going to appoint," and he delivered. As Jason pointed, we saw both Kavanaugh and Gorsuch coming off of that list. And as a result, we've seen a massive shift in the court, and I think that Jason touched on something that within political science we've talked a lot about polarization since the 1990s that hasn't quite made its way to the Supreme Court yet, but I think we're getting to that era. That while we've seen the middle disappear from Congress, we don't see moderates really anymore. I think we might reach a point where we're starting to see that on the Supreme Court, that the moderate positions that had been held by Kennedy and O'Connor, we've now seen a shift in our median justice, our middle justice to Justice Roberts, who's certainly more conservative than any median justice we've had to this point, at least in the recent history of the Supreme Court. And so if as we're looking ahead to the 2020 election, particularly given the role that it played in the 2016 election, we no longer have a let's protect the court at all costs that was in the mind of the Republicans in the 2016 election, where they were looking down the scope of potentially a replacement of Scalia with a liberal justice, potentially if Kennedy were to step down, a shift towards a more liberal perspective. Now we're looking at a question of whether or not the Republicans are going to continue forward for the possibility of a 7-2 court with 7 Republican justices, or 7 justices appointed by Republican presidents and 2 from Democratic presidents, as we have obviously the eldest justices on the court that are left are Ginsburg and Breyer, who are both in their 80s and are both part of the liberal bloc. So I think it'll be interesting to see the way that the Supreme Court is brought up in rhetoric in the 2020 election. How, we've already seen some extent of let's talk about packing the court, let's talk about these types of things brought up, but not necessarily. I think Trump was very smart in the way that he approached it. Is he made it an issue, and did so in a way of saying, here's what I want, here's what I'm going to do, and that's kind of the path that I took. So it'll be interesting to see if Democrats can try to match that going into the 2020 election.
Well, thanks everybody for coming. Thanks for inviting me, Jason. There's a lot to talk about. Let me first double back to some of Jason's comments about the choice of this date as Constitution Day. I think it's relevant that when Congress passed the statute that you're talking about, Jason, and they changed Citizenship Day to Constitution Day, that was 2004. 2004, roughly speaking, marks the heyday of what I would call first-generation originalism, where Justice Scalia had a lot of impact over the previous 20 years on the court. But the first-generation originalism tended to focus more on what the people in Philadelphia, behind closed doors, James Madison and others, what they said and thought and had on their minds, kind of subjective intent of the proposers. Whereas today, most originalist scholars and many originalist judges focus instead on the original meaning, the public meaning of the words at the time of adoption or enactment. Not necessarily the subjective intent, what the people who wrote them were trying to get at, but how people would understand them to apply to the real world. And so if we were picking the day today, I think picking the day that the Constitution became law, that it was ratified by the Ninth State, would be more in keeping with kind of the general interpretive ethos that prevails. I thought maybe I would talk about where the court has been the last few years as a jumping off point to see what might happen with the election. I think Alicia is certainly correct that the fulcrum has moved from Anthony Kennedy to John Roberts, and also I would say Brett Kavanaugh. We don't know enough about Brett's rulings yet, but based on his D.C. Circuit rulings and what I know of his scholarship, I would expect that he would join Roberts in a lot of cases where Thomas and Gorsuch and Alito might stake out a more extreme position. Kennedy was the balance, and in some ways Kennedy was more liberal than Roberts, but not across the board. Kennedy was not a guy who always split the baby the way Lewis Powell was, or the way Sandra Day O'Connor was in a lot of cases. He was always overly confident in his view, but it's just that sometimes his view was with the conservatives and other times it was with the liberals. But remember, Anthony Kennedy wanted to strike down all of Obamacare in 2012. It was John Roberts that pulled the pin on that one. So if you look at the areas where Kennedy, where liberals kind of lionize Anthony Kennedy, and I remember when Kennedy was appointed, no one was thinking this is a Reagan appointee, he's a Ninth Circuit judge. I clerked on the Ninth Circuit. No one was thinking, oh, he's gonna save kind of all these liberal causes. It's same-sex marriage and same-sex equality. On that issue, I think John Roberts is certainly not going to try to unravel what's already been done. He has no appetite, and neither does Kavanaugh, I think, for trying to undo same-sex marriage rights. Extending same-sex equality rights, especially in the statutory realm, is another question, but I'm not even sure how Kennedy would have approached the big cases this next term involving the meaning of the phrase on account of sex and how it applies to gay and lesbian and transgendered folks. Then we got affirmative action, where Kennedy surprisingly upheld the University of Texas's plan in 2016 in Fisher. Up until that point, he had been as or more vicious a critic of race-based affirmative action than John Roberts. There's an area where I think Roberts and Kavanaugh probably will be more open to sending a message to universities and lower courts that it can't be used as aggressively as it has been. But the big driver is abortion. And that's where Kennedy was a little bit more of a middling person. He joined the middle group in Casey to preserve some diluted version of Roe versus Wade. And John Roberts is probably, along with Brett Kavanaugh, much more open to incremental chipping away of abortion rights under the undue burden standard. They're not going to overrule Roe. There's nothing in it for them to do that. They can accomplish pretty much what they want to by upholding laws like the one that was struck down a few years ago with Kennedy's vote and Roberts dissenting in Texas versus Whole Health, the Hellerstedt case. And that's a case that was illustrative because it involved regulations that in practice reduced the number of abortion clinics in a particular region, in that case Texas, significantly, making abortion not so much harder for well-to-do people who can travel across state lines or people who can afford to take time off of work, but really poor rural women are the burdens of law, the victims of laws like that. And I would guess that over time, Kavanaugh and Roberts would loosen the constraints on that. But notice there was a Louisiana statute that was very similar to the Texas statute that the lower court had struck down on the basis of that Texas case, and the Supreme Court, including Kavanaugh, didn't reach out to grab it and use it. So I think they're going to bide their time a little bit in that area. Let me double back to this theme that Jason helped put on the table about kind of original intent versus the public meaning of a law, because I think that actually highlights one of the three themes I want to put on the table that characterize the court's last couple of terms, especially this last term. If you take a step back, it's really easy to see not all, but most of the court's most hot-button cases, the most headline-grabbing cases, in terms of invidious motive by government officials. So these are challenges to laws that on their face would be permissible except for the claim that the government was doing it for a bad reason. So in this category, I would include the census case. Those who say that the census could never ask about citizenship don't know what they're talking about. Jason mentioned Section 2 of the 14th Amendment, which says that Congress can punish states who deprive adult men of the right to vote relative to the number of citizens they have in their states. How are you going to punish them if you don't know how many citizens are in each state? The United States has asked citizenship questions for many decades until the 1950s. So it's not a generically problematic question. It's problematic only to the extent that it was motivated by some really bad purposes. The partisan gerrymandering case, the Richo case, Ritchie versus Common Cause. The lines as drawn aren't objectionable except insofar, in the eyes of some people, that they were motivated by a desire of one party to stick it to the other. And the court didn't take the bait there and stayed out of that. Another big case this year involving peremptory challenges, Flowers versus Mississippi. Again, the claim in peremptory challenge cases is that the government is doing something, in this case a prosecutor, is removing jurors for the wrong reason, that is because of a racial mindset. The big case involving the Latin Cross, the World War I memorial, was a case about whether the government was trying to send a religious message by maintaining a particular symbol. Go back to last year, the travel ban case, so-called. There's no doubt that in general, the president has wide latitude to impose security screening in a differential way on people coming from different countries, because those different countries have different political systems, they have different relationships with the United States, they have different levels of internal screening. But the claim there always was not that this is generically problematic on its face, but that it was motivated by an anti-Muslim sentiment. So this is the big theme that is being invoked more and more often, and to be honest, not very successfully. And the reason it's not being invoked very successfully is that it's often being pitched at the level of Congress or the president. And when the Trump travel ban case was pending a year and a half ago, and a lot of lower courts had struck down the so-called travel ban, my older brother is a constitutional law professor too, and we were kind of among the few left of center constitutional analysts who write about stuff out there in the blogosphere, who were very skeptical that this claim would or should succeed. And at one point I said to my brother, I said, how many times has the Supreme Court ever struck down a law by Congress or the president, a regulation, that's facially unproblematic on the ground that it's motivated by some impermissible religious or racial sentiment? And the answer is zero. Zero. It's one thing to strike down a city ordinance or even a state law. The Supreme Court just doesn't do that to Congress or the president. Now, obviously, this is a different kind of president with a different kind of paper trail and the like, but this was also a case involving borders and national security. And by the end of the iteration, the anti-Muslim travel ban was a pretty weird-looking anti-Muslim travel ban, because you had countries like Korea and Venezuela in there, and you excluded countries like Pakistan and other big Muslim countries. So claims about invidious intent are really hard to make. The burden is really hard, and it gets harder the higher up the governmental ladder you are challenging. So in the census case, Chief Justice Roberts, kind of like he did in the Obamacare case, he found a way out. He did not accept the plaintiff's claim that the census citizenship question was motivated by something that was racially or ethnically or religiously inspired. Instead, he simply said, the reasons that you've offered don't match the administrative record, and there's a technical statutory Administrative Procedure Act requirement that they do, and so we'll send it back to you, knowing full well that time was running out, and notwithstanding the bluster of the administration in trying to regroup, that the question would not be asked this go-round. But I think you should continue to keep your eye on this question of invidious motive. Subsidiary questions housed within that are, what are we to make of Twitter as an evidentiary tool to figure out motive of an individual atop an executive hierarchy, and what does that mean about regulations that go through a much more prolix process within the administrative branch? These are big questions that we may have to undertake, the court might have to dive into more depending on the 2020 election. A second big theme that has emerged in recent years, and we saw it this last year jump out, is a discomfort by people, even maybe especially among the conservative justices, with the extent to which Congress has given away delegated broad power to the executive branch. There was a case last year called Gundy versus United States involving the Sex Offender Registration Act. And this is a federal statute that requires sex offenders to register, and it subjects them to all kinds of limitations. But the statute was relatively silent about how it applied to people who were committed of sex crimes prior to SORNA's enactment. That's the name of the statute. So was it prospective only, or was it supposed to reach back and apply to people who've already been convicted, to the extent that you can do that under constitutional principles of ex post facto and due process? But the statute seemed to just say to the Attorney General, yeah, apply it retrospectively however you want to. And there was a challenge to this statute saying you cannot just give to the executive branch the power to determine who the law applies to. We may know what the registration requirements are, but an important element of a law is not just what it requires, but who it requires it of. And you can't just give that to the executive branch. That violates the non-delegation principle. The court finessed the issue by holding that in context, there really was guidance given to the Attorney General, and he acted within that framework. But 4 justices, with one not participating, so 4 of the 8 who participated, said they were willing to revisit this whole big question of whether Congress violates the Constitution when it gives too much unbridled power to the executive branch. It hasn't been since the 1930s that the Supreme Court has struck down a law as violating this so-called non-delegation doctrine. And many federal statutes, many prominent federal statutes, the Clean Air Act, the Clean Water Act, they constrain the executive branch not at all. Clean Air Act says to the EPA, make the air clean. Same with the Clean Water Act. So the willingness of 4 justices, or maybe 5, to revisit this is huge. Now, they haven't come up with a test. The reason the court has stayed out of this for 60 years is because no one can come up with a good line that distinguishes permissible discretion, because the executive branch always has to have implementation discretion. Congress can never write a law so tightly that there's never any wiggle room. But when wiggle room segues into giving away the farm, no one's been able to formulate a line there, and these justices haven't proposed anything very workable yet either, but they're willing to try. The final theme I want to highlight is renewed, or probably there's always been a lot of carping about stare decisis, and whether the justices who are overruling a prior case are paying proper respect to the work product of the past of the court. But you see the level of screechiness getting ratcheted up, especially by the 4 more moderate to liberal justices led by Justices Kagan and O'Connor. Kagan and Breyer, who have been bitterly complaining that this is a lawless majority that is riding roughshod over the U.S. reports. And, I like stare decisis as much as the next guy, but I think it's important to figure out why stare decisis exists in deciding when it should apply. Remember, although this is often forgotten, stare decisis matters only when the first ruling that you're considering departing from was wrong. If it was correct, you just follow it because it was right. Stare decisis has relevance only when you are maintaining something you admit was a mistake, a misinterpretation of the Constitution. If it was the right interpretation, you just adopt it again as the right one. Stare decisis does the work when it's better to be consistent than it is to be correct. And sometimes it is better to be consistent than it is correct, especially when there has been reliance on that earlier ruling. But the liberals on the court now have taken the extraordinary position that even if there's no reliance at all, that we still shouldn't correct what we all concede to be was a mistake, even a clear mistake, because it just sends a bad message about the stability of the law. And let me remind you, if you took that position, you probably couldn't have had Brown versus Board overturning Plessy versus Ferguson. You certainly couldn't have had Lawrence versus Texas overturn Bowers versus Hardwick. There was nothing unworkable about the Bowers versus Hardwick doctrine. There was no mistakes of fact that we're looking to fix. It was just that we saw the law in clearer light in Lawrence, and we decided quite rightly that the Constitution doesn't permit punishment of people because of their sexual orientation. But a lot of the cases you love the most overturned past cases. So before you think through your way through this stare decisis debate, read some commentary and see what the arguments that are being made really are. The final thing I'll say about that is, the biggest case of the term, the partisan gerrymandering case, which I tend to think was actually correctly decided, even though I don't particularly like partisan gerrymandering, was Rucho versus Common Cause. And Justice Kagan wrote a dissent there that's really kind of, out there. But Kagan, who's been banging the drum about stare decisis, has been on a summer tour this summer saying how Rucho's not really going to be binding and we're going to fight it again and again and again. I'm like, well, how are you reconciling this with the tenor of what you've been saying for the past 2 years over and over? And by the way, the Supreme Court, and this is what I'll close with, the Supreme Court overturns past rulings these days, most often in technical cases involving dormant commerce clause or state immunity. I mean, there was a big one from Illinois last year involving union fair share fees. That's Janus. But most of the time, these are relatively obscure cases that were takings clause procedures. But it does so at a rate pretty similar to the rate at which it invalidates congressional statutes. So it might overturn 2 past cases a year and strike down 2 congressional statutes a year. And I actually think that's a kind of a nice symmetry, that they're not taking their own past work product with any more greater degree of reverence than they're taking Congress's output. So we'll stop there. As to whether the Supreme Court is not well, according to these 5 senators, I don't think it's in great shape, but it's not as sick as most of the rest of society. So I'll leave it at that.
So I guess just a couple of thoughts provoked by Vic's comments and also those of Alicia. I'm thinking about the center of the court and Roberts versus Kennedy. I do agree with Vic that Kennedy, he's more conservative than, say, the marriage case would give you the impression. He was this kind of libertarian. I think at the end of the day. But now thinking about, well, where is the center of the court now? One thing to keep our eyes on going forward, and I think this would be particularly true if there were another appointment by President Trump, is on Justice Thomas. And so Vic had talked about, Justice Thomas for years was sort of laboring away, writing his own opinions, hard to get anyone else to sign on to them because they were seen as sort of too eccentric and so on. I always thought he was a very interesting and thoughtful member of the court. I saw Justice Thomas a few days before the most recent presidential election, and he gave a speech, and I was riveted because I thought the speech was leading up to him announcing his retirement. It really sounded as though that was where it was headed, and of course he didn't do that, and he is. I think newly reinvigorated, but more importantly, some of the views that he had sort of been laboring on his own are increasingly attracting votes from other justices. And I think in the stare decisis context, this is one example. Justice Thomas's view on stare decisis is if the prior case was wrong, then it is wrong, and you overrule it. Your obligation is to follow the Constitution, not some prior decision of the Supreme Court. You can argue about that, but that is increasingly commanding or attracting votes from other members of the court. And I think in other areas as well, we might see some of Justice Thomas's views perhaps moving towards the center, not on everything, but he may be playing a more central role going forward. The other thing, sort of thinking about the current president and the sort of relationship with the Supreme Court, I just want to flag that the Chief Justice, who doesn't give a lot of, doesn't give speeches criticizing the other branches of government, put it that way, did respond a year or so ago to a tweet by the president that he had lost in court because of Democratic judges in the lower courts, right? And Roberts gave an interview with media, which he never does, in which he said, among other things, that there are no Democratic judges, there are no Republican judges, so defending the lower courts. But at the same time, one of the themes is to build on things that Vic has observed, and that I'm going to be continuing to watch going forward, is increasingly a sense in certain areas of the Supreme Court, despite Roberts's professed high regard for the hardworking judges throughout the country, a sense of distrust of lower court judges in certain areas. And so I think we've seen this in the travel ban case. I think we saw it recently in the asylum area, where the Supreme Court took, I think, a fairly extraordinary step of vacating an injunction that had been issued by the lower court, blocking a presidential order that required those seeking asylum to do so in the first country that they pass through, rather than wait until they reach the United States. We've seen it also with respect to the border wall, and so maybe it's in certain areas. Maybe it's because some of these district court judges themselves are being unusually aggressive, issuing and insisting on issuing nationwide injunctions, which raise complicated issues of procedure. But the Supreme Court, a majority of the Supreme Court, being willing, when asked by the president, and this is an executive that is happy to go quickly to the Supreme Court, willing to shut down some of the excesses that we see in the lower courts. And so we'll see if that continues. It may be because of the things that the president is doing, and again, it's not across the board, but certainly in some areas of the law.
So let me just comment briefly. I think that last point really amplifies something Alicia said, which was, we have this increased polarization in other branches and in society more generally, and how it's creeping into the courts. Arguably, and I haven't looked at anything empirical, but arguably that will have more of an effect at the lower courts before it really is apparent at the Supreme Court, by virtue of the fact that lone district court judges have so much power, if not checked, to arrest so much stuff, that you can have outliers at the district court level are a lot scarier than outliers at the Supreme Court, because you got to get 5 votes to do anything. Relatedly, when you have multi-member panels, there's a chance to really kind of point out the excess of people's ways of thinking. That's even more true at 9 than it is at 3 for the Court of Appeals. And then relatedly, the polarization that we've been seeing is not uniform throughout the country. There's a regionalization to the polarization, and our federal courts of appeals are distributed regionally, so you're going to have kind of like minds in various states and like. One final thought about stare decisis. Jason's certainly right that Thomas has been the one who has taken stare decisis least seriously over the years, rightly or wrongly. I think he doesn't give it its due. But I want to be clear, I'm not remotely convinced that the conservative justices who've overturned cases in the last few years are approaching stare decisis any differently than they ever did before. With the exception of Janus and maybe a couple others, I can't identify a single case where there was a strong a case for reliance, where there was a lot of reliance, where the court pulled the rug out from under people. In all the other cases where the dissents are carping, and by the way, remember, stare decisis is a great thing to argue if you're a lawyer or a litigant. You want to win your case. You want to get the judge to follow past precedent. Once you've lost a case, you're a dissenting justice, why are you talking about stare decisis? Because there's a new stare decisis in town. And if you're talking about how important it is to preserve, stability, you've just made it harder to undo the mistake that you see today. So I don't know that Roberts and the others have disregarded past cases anymore. Indeed, In the case that's the most hot button, the Rucho, the partisan gerrymandering case, one of the noteworthy but under discussed facts is Roberts' majority opinion embraces the majority in a very important case where he wrote a vicious dissent 4 years ago, the Arizona redistricting case, where Arizona had taken power away from the state legislature to give it to an independent redistricting commission as a response to partisan gerrymandering. And Roberts ruled, he voted in favor of the elected legislature, saying the people of Arizona can't do that because when the federal constitution says that the legislature of each state shall prescribe the times, place, and manners of elections, that means the elected legislature, not some independently created body. He lost. Ruth Bader Ginsburg wrote, I think, the best opinion of her career in that 5-4 decision. But I was quite worried that with the addition of Brett Kavanaugh, that 4 dissenters in that case might become 5. But all 9 justices now in Rucho seem to embrace that decision, and there was no guarantee of that. And yet, that for stare decisis reasons, Roberts not only said that states can take their districting decisions away from the elected legislatures, but maybe they should if they continue to think it's a problem because the federal constitution doesn't really speak to the matter.
So can I ask you a question?
Yeah.
Tap into the benefits of your expertise. Is there evidence about the extent to which Democratic voters care about the Supreme Court?
So, I don't know.
Okay. It's a good research project.
Yeah, there you go. I think that. So it's interesting. I think because of how the makeup of the court has been for so long that, we had an almost all complete Democratic court following Roosevelt into Truman, and it wasn't until Eisenhower that we even got Republicans on the court after a couple decades. So I think it's possible Democrats have just taken it for granted for a long time, whereas Republicans have been outcrying judicial activism of the liberal court for so long that I think that the idea of capturing it is something that has emerged. That possibly, as we're seeing this shift in the court, we might see this become more important to Democratic voters.
I mean, one related question, the Republican voters caring so much about the court in the last election, I'd love to know exactly which issues they're really driven by. Because it may be that, people who care about abortion and regulating abortion are more single-issue voters than people who generally want abortion to be available on a wider basis. So it may be a more diffuse kind of support, and that's always the problem with the court. I don't know enough about what's been successful in the Republican rhetorical appeal.
Right.